Friends, there are a large number of the legal channels, legal journals. They have been publishing the legal news about the recent judgment given passed by this Honorable Delhi High Court on 2nd of July 2024. And this is the writ petition number 4733 2024, and citing that the WhatsApp messages shall not be treated as an evidence unless being supported by some certificate. So if we see the facts of this case, and we will know more about this judgment. So this is means the petitioner versus the respondent's case was there, and the respondent has filed a consumer complaint against the petitioner or the applicant here in this case. So he has filed a consumer complaint before the District Consumer Redressal Commission, and on the basis of the complaint, summons were issued, and the respondent was directed to file the written statement. But the respondent has made some WhatsApp conversations with the respondent that the complete record has not been sent, and kindly send the complete record. But thereafter they filed the written statement. There was a considerable delay of 10 days or 10 days or 5 days, as we will see in this judgment, in filing the written statement, and the application of the condemnation of the delay was also being filed, but the District Consumer Court has rejected their application, and then aggravate against that order they filed a revision petition before the State Consumer Redressal Commission. The State Redressal Commission too have dismissed their applications, and aggravate that order they filed a writ petition before the Honorable Delhi High Court of Delhi. Honorable Delhi High Court of Delhi had made a suggestions to kindly file a CMM, civil miscellaneous main, as the role is more supervisory, because Article 226 of the Constitution has their own original jurisdiction, but the petitioner chooses to file a writ petition, since there is one another remedy was available in case the writ petition get dismissed. They can file the LPA, but against the order of the CMM, there is no provision of filing the LPA. So these were the reasons the petitioner have cited, as we can see in there in the judgment. Let's see the contents of the judgment, and then we can make a more we can make more inferences there on the basis of these legal principles discussed by this Honorable Delhi High Court of Delhi. And let's see the contents there. The petitioner has approached this court under Article 226, 227 of the Constitution against the orders of District State Consumer Redressal Commission in the revision petition number so filed by which has upheld the order passed by the Consumer Dispute Redressal Commission. Consumer dispute resolution, I here refer to the District Commission, means District Commission has passed an order in the complaint case number so against that order they filed a revision petition, which was also dismissed, and against the revision petitioner order passed in the revision petition, the petitioner now chooses to file a writ petition before this Honorable Delhi High Court of Delhi. So the facts of the case are there. The consumer forums are the tribunals are vested with the powers to determine conclusively for the rights of two or more contending parties with regards to the matter controversy between them, and being a purely judicial tribunal mattering them. And the court has given a suggestion that, as the learned counsel for the petitioner, that it would be appropriate for the petitioner to file a civil miscellaneous main, which is appropriate courts while approaching this court under the Article 226 of the Constitution of India. However, the learned counsel for the petitioner declined the suggestions of this court and contended that since the writ petition is a composite petition under Article 226 of the Constitution of India, same is maintained. The court has made a suggestion to kindly file a CMM, because the High Court has also the supervisory power. 227 is the supervisory power over all the tribunals, over all the courts lying within their jurisdiction. But the petitioner says that we have filed a writ petition which is a composite, means powers of 226 as well as 227. So they have declined the suggestion of the Honorable High Court, and It is also pertinent to mention Article 226 of the Constitution holds the original jurisdiction, and Article 27 holds the appellate jurisdiction. If we file a writ petition there before the Honorable High Court, so they have the original jurisdiction, and if we club the 226 of the Constitution, they have also got this supervisory power against the appellate jurisdiction. So petitioner present petition arises of the order passes and writ petition. Therefore, the petition court is sitting as an appellate authority over the revisional order passed by the judicial tribunal. So this they have cited the judgment passed previously passed by the Honorable Supreme Court. Instead of filing the present petition as CMM, the petitioner has chosen to file the writ petition under Article 226 for the reasons that LPA would not be maintainable against the order passed by this court in CMM space. So the petitioner have this ground. So in case the CMM get dismissed, so they have no other remedy available. So in case the writ petition get dismissed, they have their remedy. They can file a letter of patent appeal LPA, which is only been maintainable in the order passed by the Honorable High Court in the petition. So LPA is not maintainable in the order passed by the Honorable High Court in CMM, but in the writ petition they have their remedy. So now comes to the facts of this case. The fact says respondent number 1 filed a consumer complaint against the petitioner before District Commission on 19th of September 2022, and summons were issued on 16th of November 2022. Summons were received by petitioner on 23rd of December 2022. Documents received by the petitioner on 23rd of December 2022 were incomplete. This was the version of the petitioner, that they have received the summons, they have received the document, but it was incomplete. On the basis of the documents received by petitioner, a written statement was filed by the petitioner on 31st January 2023. Means after a period of more than period of 1 month, they have filed a written petition. This WS was objected by the respondent number 1 before the District Commission, as it was filed beyond the time prescribed, but the same was taken on record. It also stated that the complete documents was handed over to the counsel of the respondent number 1, head to the counsel of petitioner before the District Commission. On 18th of April 2023, a rejoinder written statement was filed, and on 16th of May 2023, an application for the continuation of the delay of 7 days in filing the written statement was filed by the petitioner before the District Commission. Since they are out to have filed a written statement on 22nd of January, but they chosen to file on 31st, 23rd or 22, and they have filed application with the 7 days of delay, which will kindly condone the days of 7 days. So this application was filed, but the district forum has dismissed this petition, and they refuse to condone the delay of the 7 days filed written petition because false case put by the petitioner hearing. Because of the false case, so the court, the district forum refused to condone the delay because they say it's the false case, and this is the contents of order says that local documents 1 to 13 complete pages were for 1 to 15, and remaining pages were next 16 to 13. It would not be possible to wait same weight of the article. The complaint was sent to the opposite party. It infers and proves that opposite party was served with a complete record. Otherwise, opposite party would have mentioned on the WhatsApp in annexures were not received. The court says that it's a false case framed by the petitioner, so that's why they refuse to condone the delay, because they say they should mention in the WhatsApp messages that they have not received the complete record, because the weight says they have to receive the documents. So they've aggravated against the order. They filed a section 47B of Consumer Protection Act. It is a revision petition before these State Consumer Redressal Commissions, and the State Consumer Redressal Commission to dismiss their petition on 12th of December 2023. They're finding that there was no material irregularity on their order passed by, and they refused to exercise the revisional jurisdiction. So then the petitioner filed against the order of the this State Redressal Commission. The petitioner filed a writ petition, and the petitioner filed a screenshot of the conversation between the petitioner and the respondent were to demonstrate the entire copy of the complaint along with the annexures was not received on 23rd, and it was only handed over to the counsel of the petitioner of the district firm only on 31st of January 2023. So they have made means in the writ petition they have filed a screenshots, and screenshot says that the petitioner here in this case has not received the complete documents, and complete documents were only been handed over on the next date of hearing when they filed a written statement on, that is on 31st of January 2023. So this was the main ground raised by the petitioner. They have annexed the copies of the WhatsApp messages, and this was the details of the in the writ petition. And now court has made their own observations. It says district commission examined the matter great in detail. It's called for the postal receipts of the documents which were sent with the summons and were received by the petitioner on 23rd of December 2022. The district commission analyzed the weight of the documents sent along with summons and the postal charges, came to the conclusion that complete set of documents along with the summons and same was received by the petitioner on 23rd of. The court says the district commission has already analyzed this matter. They have passed a very speaking of they passed a detailed order. They call the postal receipts and they weights the envelope in which the documents were sent. So the district commission has made their observation that complete record has been filed by these has been sent by the complainant to the petitioner. Petitioner here was the respondent in the district commission. So the district commission therefore held that the application for petitioner was herein for the condemnation of 7 delays in the written statement is not bona fide. So they have dismissed the petition on the ground that the ground raised by the petitioner is not bona fide. The court under Article 226 or 227 Constitution is examining the present matter as the appellate authority and exercising the power of superintendence. So means court has the powers. High Court has the power under the 226 to 27 as the appellate authority as well as the power of superintendence. Means they supervise all the tribunals lying within their jurisdiction. So present petition is not a writ of certiorari. It's well established that even assuming that instant case is one under the writ of certiorari, then also the High Court does not sit as the court of appeal and is only concerned with the question where the tribunal has not acted without jurisdiction or contravenes with the provisions of the natural justice. The court says that since this petition is not filed under certiorari, the court also assumed that Honorable Court assumed even if the case has been filed under this writ of certiorari, then again they can't act as the appellate authority because they will act only against where the tribunal has acted without following the principle of natural justice or against are acted illegality. Some illegalities there or not having the jurisdiction there. So then only this Honorable High Court has got the powers there. The court cannot substitute its own decisions to one arrived by the authority just below because another view is possible. Means the court says if two views are there and that lower court has made one view and with some explanation is there, then also the court cannot substitute their view with their own view. So there must be some logic, there must be there. So view taken by the forum is perverse or arbitrary. If the view is perverse or arbitrary, then only the High Court has the power to change the view. But if it's not suffered from any legality, it's not arbitrary and it's not perverse, then court has got the limited powers. The screenshots of the WhatsApp contributions cannot be taken into account by this court while dealing with the writ petition under Article 226 of Constitution of India, when there is nothing to show that conversation was before the State Commission, as this court doesn't find any reference in the same in the writ petition. Further, there is no discussion of the same in the order of the State Commission. If in any event, WhatsApp conversations cannot be read as an evidence without there being proper certificate as mandated and under Evidence Act 1872. The court has found that these conversations are annexed by the petitioner in this writ petition. The court says this can't be treated as an evidence unless being supported by some certificate, which is mandatory under the Indian evidence certificate. So these messages must be supported by some proper certificate. So court says we can't make our view on the basis of the chat messages which were, because even before the state commission these were never been produced, and not state commission 2 have not discussed this in their orders. So in short, the court says the powers is limited unless the court has not means that the lower court has not acted in a perverse manner or gross illegality has not been committed. And then now come to the section 38(2) subpart A of the Consumer Protection Act, which says the procedure on admission of the complaint. And the part A says refer a copy of the admitted complaint within 21 days from the date of admissions to the opposite party, mention in the complaint, directing him to give his version case within the period of 30 days or such extended period not exceeding 15 days as may be granted. So this court says this section shows that period of filing the written statement after receiving the copy of the complaint is 30 days only, and but the same can be extended up to the 15 days if district commission deems it fit to do so. So in this present case, court has made an observation that summons were issued on 17th of December 2022, and the petitioner received a copy on 23rd of December 22, and the period of 30 days gets over on 21st of January 2023. The petitioner filed a written statement only on 31st January 2020 and raised a plea that he had not received the complete documents along with the summons. When in fact complete set of documents have been served to the petitioner along with the summons, as it is evident from the weight of documents sent along with the summons and the postal charges. The court, in this view above, the court doesn't find any reasons to hold that the reason given by the district commission in refusing to condone the delay in the finding the written statement erroneous. So the court says that we do not find any of the means merit in the petition or any other order passed by the district consumer forum is suffered from any illegality. So they says we can't interfere in that order. There's order we cannot find that there is some erroneous approach has been adopted by the district commission. So writ petition is dismissed along with the applications thereof. If any. So this judgment came on the 2nd of July 2020.
उम्मीद है कि यह वीडियो आपको पसंद आया होगा। अगर आपने अभी तक हमारे चैनल को सब्सक्राइब नहीं किया है तो कृपया इसे सब्सक्राइब कर ले और बेल आइकन दबाकर नोटिफिकेशन प्राप्त करें ताकि आप हमारे नए वीडियो से अपडेट रह सकें। अगर आपको यह वीडियो पसंद आया हो तो कृपया लाइक करें और अपने दोस्तों के साथ शेयर करें। हमारे चैनल पर आपको न्यायिक मुद्दों, कानूनी सलाह और कानूनी अपडेट्स के बारे में नवाचारिक और महत्वपूर्ण जानकारी मिलेगी। हमारे साथ बने रहें, क्योंकि योगेश महाजन लीगल आपके कानूनी सवालों का सहायक है।